Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the legal dictation at the speed of 120 words per minute. Soul searching is absolutely necessary and the blame game and maligning must stop forthwith. Confidence and reverence and positive thinking is the only way. It is pious hope that the Bar Council would improve upon the function of its disciplinary committees so as to make the system more accountable, publish performance audit on the disciplinary side of various bar councils. The same should be made public. The Bar Council of India, under its supervisory control, can implement good ideas as always done by it and would not lag behind in cleaning process so badly required. It is to make the profession more noble and it is absolutely necessary to remove the black sheep from the profession to preserve the rich ideals of bar and on which it struggled for the values of freedom. It is basically not for the court to control the bar. It is the statutory duty of bar to make it more noble and also to protect the judges and the legal system, not to destroy the bar itself by inaction and the system which is important pillar of the democracy. In Kamini Jaiswal versus Union of India and another 2018 1 SCC 156, it was observed in Charan Lal Sahu versus Union of India. This court has observed that in a petition filed under Article 32 in the form of PIL attempt of mudslinging against the Advocates Supreme Court and also against the other constitutional institutions indulged in by an advocate in a careless manner, meaningless and as contradictory pleadings, clumsy allegations, contempt was ordered to be drawn. The registry was directed not to entertain any PIL petition of the petitioner in future. In R.K. Anand versus Delhi High Court, this court observed that there could be ways in which conduct and action of malefactor was professional misconduct. The purity of the court proceedings has to be maintained. The court does not only have the right but also an obligation to protect itself and can bar the malefactor from appearing before the court for an appropriate period of time. There is a duty cast upon an advocate to protect the dignity of this court, not to scandalize the very institution as observed in the said decision. We expect members of the noble fraternity to respect themselves first. They are an intellectual class of the society. What may be proper for others may still be improper for them. The expectations from them is to be exemplary to the entire society. Then only the dignity of noble profession and judicial system can be protected. The registry is nothing but an arm of this court and an extension of its dignity. Bar is equally respected and responsible part of the integral system. Registry is part and parcel of the system and the system has to work in tandem and mutual reverence. We also expect from the registry to work efficiently and effectively. At the time it is expected of the lawyers also to remove the defects effectively and not to unnecessarily cast aspersions on the system. Thus, we find no ground to entertain the petition. We expect the petitioner to be more careful and live up to the dignity of the profession which it enjoys. We dismiss the petition and impose cost of rupees 100 rupees or 100 only on the petitioner as a token to remind his responsibility towards noble profession and that he ought not to have preferred such a petition.